seated, please. All right, our final case for this morning is Curtis Farber versus St. Johns County.
Morning, Your Honors. May it please the Court. Dean Morandi here with Thomas Warner from Carlton Fields on behalf of the appellant, Curtis Farber. The appeal in this case is really controlled by this Court's prior decision coming from this very same case. The Court expressly held that the county has a duty to reasonably maintain Old A1A as long as it's a public road dedicated to a public use. The county must provide a reasonable level of maintenance that affords meaningful access unless and until the county formally abandons the road. With regard to the arguments here, just as it was in that case, the argument is that the county so failed in its reasonable duty that it effectively abandoned Old A1A, thereby depriving access to the property without compensation. As this course
before your client purchased the property, I mean, how did the access change, if at all, between the time he purchased the property going forward?
Well,
when he purchased it, he was using what they referred to as the pig trail.
Right, the pig trail was a way to get through, correct. If you look solely at the physical part of the road in the part adjoining just his property, you wouldn't see much of a change there. There's a couple points to that. The road was there. The pavement was not. The road was there. The 100-foot right-of-way, almost all of the 100-foot right-of-way remained. And most importantly, what remained when he purchased this property for $650,000 in June of 2005 was the county's duty to provide meaningful access, to provide reasonable maintenance that at a minimum provides meaningful access. That is what was there at the time Mr. Farber purchased the property.
Let me ask you this. Let's say from 2000 to 2010, there was no meaningful access to your client's property by Old A1A. The only meaningful access was by the big trail. And let's say the property was conveyed each year. So you had 10 different property owners between 2000 and 2010. Would each of them be able to bring an action for inverse condemnation, and what would their measured damages be if so?
The short answer is, taking the statute of limitations out of the equation, right, they would each have a cause of action for the county's breach of its duty to provide meaningful access. The question, and the reason that's important, is the county has a duty to provide meaningful access unless and until it formally abandons the road. Unless it formally abandons the road of its own accord or through a judicial action finding a de facto abandonment, it has a duty to provide meaningful access.
And would the measured damages be the difference in value between the property having Old A1A providing meaningful access and the value of the property without that?
Potentially. Potentially. But here we're talking about two phases. First we need to find the taking, and next we need to find the damages.
But let's assume that for that, let's assume that in 1999, I know the dates are different, but I just want to use 2000, 2010. 1999, there's a bad storm, the county quit taking care of the road, there's no meaningful access on that road, and that continues to 2010. And there's, like I said, there's 10 property owners, and within the statute of limitations, they each bring an action. And if the measure of damages is the difference in value, do we have a problem here with 10?
Well, not necessarily. I would say that the damages would not be, perhaps there would be a compensable claim, but I don't think the damages would be very high. Because just as in this case, when Mr. Farber purchased the property for $650,000, at the state of the property it was, I would think in your hypothetical, you would still be getting fair market value as you go through. And part of that bundle of rights includes the right, or the county's duty, to maintain the road and provide meaningful access.
But if the property is worth $650,000, with meaningful access and worth $200,000 with having to rely on the pig trail, would each of those 10 people be entitled to $450,000 under your theory?
Well, I guess it's all going to depend on what each property owner sold it for subsequently.
Why would that make a difference? If the measure, I think the normal measure is the difference in value between the
Right.
the
What they sold it for is
property without the taking by the government and the value with the, after the taking.
Right, I think you're going to see the value of the property reflected in what it would be sold for. I don't think the county is going to be paying over and over. We have to assume that the market is going to provide a reasonable price for whatever the property is worth.
Well, if the market's going to provide for it, wouldn't that have kicked in when your client purchased the property?
It did. That's why it was $650,000. It wasn't $2,500 as it was the next year after the county imposed this moratorium and decided that this road, and finally officially declared that the road is unsafe because we can't provide access for emergency vehicles, and at the same time keeping the road as a public road. I think for your example, I don't think we can isolate the purchase price and the sale price for all those 10 people over that period of time, because I think what you'd find, and I really keep coming back to our example here. He purchased this property for $650,000. That was the fair market value at the time. It wasn't a situation where everybody walked in and knew, hey, you know, the county has a duty to reasonably maintain the road and provide meaningful access, but we just know that the county's not going to do it. No, the county has this duty. This court already held as much, specifically in the context of this case, unless and until it formally abandons the road, it has a duty to maintain the road.
Under my hypothetical, couldn't that apply if your client sold it in 2006 and that person sold it in 2007 and that person sold in 2008, with each of the purchasers recognizing that the county had a duty to maintain it?
It could, but I think, I understand, you know, you're trying to play this out to its logical conclusion, but I think if we actually get to the point of, okay, taking was declared, but what does that mean in terms of damages? I just think when we look at the purchase price, the sale price, the purchase price, sale price, it's going to be reflected there.
Under your theory, when did the taking occur?
Well, under our theory, the taking occurred in 2005, September 2005, when the county finally officially declared, the facts underlying the taking occurred when the county officially declared that it was no longer, that this road was unsafe, could not provide access from this road. If anybody wants to do it, nobody can build there. If you want to do something there, you have to sign a hold harmless agreement. Those are the facts that underlie where we say the point in time when the facts constituting a taking occurred.
So
However,
the temporary building moratorium, that was the taking?
the temporary building moratorium itself was not a taking. That's just the point in time when the county truly stated, we're not going to maintain this road anymore. It's taken that position back and forth. But at the same...
But the facts on the ground, nothing had changed at that point. There wasn't any dramatic event in 2005. That was just, you're measuring it because you're saying that's when the county acknowledged publicly that the road was essentially not there anymore.
Exactly. That's exactly the point. But the other point we can't forget is, even through that entire period, even through today, the county has a duty to provide meaningful access. Even through today, even after it imposed this moratorium. That duty cannot go away until the county formally abandons the road. Even though we have facts demonstrating when the taking occurred, the duty does not go away until there's a judicial pronouncement of a de facto abandonment, and that's what we've been seeking here. This court's decision in the prior case says exactly that. Now, there's a couple points I want to clear up in relation to the road. The trial court, the county, all focused on the little piece of road in front of Mr. Farber's house. That's not the whole road. A road includes the right-of-way, which still remained, and a road also includes the ability to travel from one place to another. It's difficult to dispute that this 1.6-mile stretch of road, the condition has been changing over the years. So even if you take it out of the incorrect framework even if you ignore this court's prior decision, you still have disputed issues of fact as to that road. Simply because you point to that sliver of road in front of Mr. Farber's house, that's not the end-all be-all of what a road is. A road requires access and the ability to get to other places. So even if you were to look to that, even if you were to ignore the county's continuing duty to provide meaningful access, there's still disputed issues of material fact there.
Let me ask you this. Subsequent to our opinion, let's assume that the trial judge made a finding that the county had not complied with our mandate. Does your client have any remedy other than damages under an inverse condemnation claim?
I'm sorry, can you repeat that one more time?
Let's assume that the county has not complied with our mandate, and let's assume a trial judge made that finding. Does your client have any remedy other than damages for inverse condemnation?
No, that would be the remedy.
I mean, are they...
Our count is under...
An injunctive case and where the county could be held in contempt if they didn't comply with the court order?
Well, no,
Or is your only remedy inverse condemnation?
Our remedy here, as we stand here today, is inverse condemnation. The problem with
My
injunctive...
question is, would there be other remedies other than the one you sought in this case?
Not that I can think of. Now, to specifically use your example of injunctive relief, this court already determined that injunctive relief is not appropriate in this situation. We're not saying that the county has to provide a full road. We're not saying that the county has to go do any particular level of maintenance. We already know that you can't order the county to do that. The floor is meaningful access. How the county gets there is up to the county. And if they refuse to do that, then we need a judicial pronouncement of a de facto abandonment, which is what happened in this case. So the count we have here, yes, is inverse condemnation.
Earlier, when apparently there was a statutory way of necessity that was determined, wasn't it about a year before your client bought the property?
10 months.
So wasn't that really a judicial determination of a de facto abandonment?
Well, no, it can't just be obliquely...
It can't be a statutory way of necessity if there's another better public way of going in.
That's correct.
So the court made a determination that there was not a suitable public method of access, thereby acting as the prerequisite for the statutory way of necessity.
At that point in time, that could have been correct. I don't know how hotly that issue was litigated because they wanted the way of necessity, but the bottom line is that's a private road. This is a public road where the county has a continuing duty to provide meaningful access. The county refuses to do anything on that front. Taking all these facts just completely off the table, the day Mr. Farber bought that property, part of his bundle of property rights was his knowledge that the county had a duty to provide him with meaningful access. The county refused to do that. The county also refused to follow the statutory abandonment procedures. The way of necessity issue, suggesting that the inferences at that point there was an abandonment because there was no other reasonable access, still doesn't meet the statutory requirements for abandoning a road. That's got to happen in order for the county to discharge its duty. And this court made that clear. This court also made it clear that the county's failure to abide by that duty can support an inverse condemnation claim. So that framework by itself demonstrates the viability of an inverse condemnation claim. Now, I understand there's an issue in relation to damages, but we're not even at that point yet. We will determine the appropriate damages at the appropriate time. One other issue I wanted to point out is the county suggests that Mr. Farber might receive some kind of a windfall here. He purchased this property for $650,000 in June of 2005. In September of 2005, the county enacted this moratorium, officially declaring this road unsafe because of the inability to provide access. At the same time, the county shifted responsibility to the property owners to repair and maintain the road while still maintaining this road for public access so that you could have public beach access. In 2006, the assessed property value in 2006 was $2,500. Mr. Farber ultimately couldn't sell the property, lost it in foreclosure, while at the same time, the county kept its road, kept public beach access, and disavowed its responsibility to maintain the road. This is not a windfall. Mr. Farber should be allowed to pursue his inverse condemnation claim. I respectfully request the court reverse summary judgment. I'll reserve the remainder of my time.
Thank you, counsel.
May it please the court? My name is Stephen Gallagher. I represent St. Johns County. In this case, I'm with the Marks Gray law firm in Jacksonville. I'd like to
Let me start by asking you, in our earlier opinion, we said the county must provide a reasonable level of maintenance that affords meaningful access unless or until the county formally abandons the road. And apparently, it's undisputed that that didn't happen, that there's no meaningful access over Old A1A. How do you square the county's position with the holding in the earlier case?
This case, Mr. Farber's case, is an inverse condemnation case. Mr. Farber is trying to bootstrap a duty to provide meaningful access into an inverse condemnation claim when he has lost no access whatsoever at all, and the road was totally gone by the late 80s, or at least by 1991. And if there was an abandonment of the road, the appellant's initial brief on pages 4 and 6 indicate that in 84 and 85, storms took out that portion of the road north of Block 21, and the county commission refused to take any action. If there was an inverse condemnation, accrual of an inverse condemnation claim, it occurred then, and it's been the law of Florida since 1911 in the Mariana Maughan case that damages for that inverse condemnation go to the owners at the time and not to Curtis Farber, who has lost no access whatsoever.
But did Mr. Farber have a right to enforce our mandate, if you would?
Well, I don't believe so, because count 2, well, let me put it this way. Did Mr. Farber have a right to enforce that? No, because he bought in after the destruction had occurred. If the destruction had occurred and a property owner had already owned the property, the enforcement mechanism is inverse condemnation for that property owner only, but certainly not to Curtis Farber.
All right, so it's your position that the only people that have a right to enforce our mandate, if you would be people who own the property as of when, 1994, or?
Well, let's deal with the entire length of Old A1A. There are folks there that have owned for a long time.
Let's deal with the northern portion.
Okay. If a property owner owns the property and the county lets the road go away, let's assume, just for the sake of this argument, that the cause of destruction of Old A1A was the county's inadequate maintenance and not the forces of nature. If that occurred, the enforcement mechanism is inverse condemnation, with all that entails. The loss of access, now substantial loss of access, according to the Tesla case. That's the enforcement mechanism. This court ruled in our last go-around here that in count 2, where the plaintiffs demanded injunctive relief, this court ruled that injunctive relief was not appropriate. Actually, the trial court did, granted summary judgment on the county's motion, and this court affirmed. And that was based on 5th DCA case law, specifically Florida Highlight Inc. versus Southern Catering Services Inc., that specific performance perpetual injunctions are not appropriate because it entangles the court in this case, St. Johns County's maintenance department.
If the county formally abandoned that part of Old A1A to the north end, would they be required to compensate any property owners?
De facto or de jure?
De jure.
De jure? If the property owners had owned the property before the road went away, yes. Those that bought in after the road went away, no.
And is that based upon your argument that the cause of action accrued whenever the road lost meaningful access?
Yes, sir. If the road is gone, if the road's gone, if that's not loss of access and a de facto abandonment of the road, nothing is, if the destruction was caused by the county.
But doesn't the county have a continuing duty to maintain the road?
It does.
Maintain a road?
According to this court's last ruling, yes.
And so if I buy the property, or maybe if I'm a member of the public, I don't know if a member of the public has standing or not, I haven't thought about that, but I want to get to the beach via this road, or I own property there, and can't I say to the county, look, y'all have a continuing duty to maintain the road, get out there and maintain it?
At that point, Your Honor, you run into the perpetual specific performance injunction prohibition that this court has recognized twice, once in the Highlight case and once in the Jordan case.
No, I appreciate the fact that the courts on separation of powers don't want to get involved in being the road maintenance department. But if I think we both agree that the county, under our ruling and under the existing law, has a duty to maintain the road. So if they don't maintain the road and they don't want to compensate people for that taking, can't the court say, okay, go maintain the road? If you don't want to pay them, maintain it.
Based on the case law in this district, as I understand it, no. I don't think so.
So you think the Highlight case says that the court can't order them to maintain the road?
The court cannot order perpetual specific maintenance activities.
Is there any remedy for someone other than inverse condemnation? Is that the only remedy
That's correct. And the inverse condemnation remedy applies only to those who own the property when the road, before the road went away.
So if there's no property owners who have maintained the property since 1994, then the county's home free?
Well, to some extent, yes. I mean, there are other property owners up there. They were involved in the original lawsuit. We've settled with all of those except Mr. Farber. Mr. Farber bought in after. His case is different and it's specific. He does not have inverse condemnation remedies. And right now, he doesn't have an injunctive relief either.
Not with the procedural posture in this case, but could a court order a governmental entity to formally abandon property, or abandon a road because they weren't maintaining it, as a remedy?
I hadn't thought of that, Your Honor. Possibly. At least that wouldn't run afoul of the Florida Highlight rationale. But it's just not something that's part of this case. And it does not affect Curtis Farber either way. Now, if I could continue, there's a discussion in the answer, or the initial brief of the Dickinson stabilization doctrine. That doctrine simply holds that if the extent of the damages is uncertain, the property owner is not required to bring suit. When the uncertainty goes away, the lawsuit can be filed and should be. In this case, when that road disappeared entirely, that eliminated all uncertainty as to the amount of damages from lack of access via old A1A, and the cause of action accrued at that time for inverse condemnation, and that occurred when other folks owned the property and not Curtis Farber. So the full extent of the damage to old A1A in that area was known by 1991. And by the way, it's not just the road in front of his place. The evidence is uncontroverted that no road existed, no pavement existed north of Block 21 since 1991 at the latest, and probably in the late 80s. That's uncontroverted. With regard to Farber's right to, well, let me, before I get to that, the full extent of the damage to Old A1A was known in 91, and the Judkins case, the first DCA case, Judkins versus Walton County in 2013, held that no Florida court has applied the Dickinson stabilization doctrine when the extent of the injury is known and the cause of action has accrued. When that road was gone, the cause of action accrued for the fire property owners. There's been a discussion of the roadway, or the right-of-way still existing. I'd like to turn that around briefly, and if the county argued today that even though the roadway was totally gone, through the fault of the county, and there was nothing but beach where the road used to be, that these residents had no substantial loss of access because the right-of-way still exists, we'd be laughed out of this courtroom. And so that illustrates the absurdity of saying, well, the situation is unstable as to the right-of-way. The evidence is uncontroverted that there was no road and nothing but beach north of Block 21, Block 21 since 1991. The last issue that I think has been raised is this continuing tort theory, that somehow that bootstraps itself into an inverse condemnation claim. The case dealing with that that's instructive and I think controlling is the FDOT versus Burnett case. The court in that case, it was a flooding case. The DOT diverted water onto the property in question before Burnett owned it, and Burnett brought an inverse condemnation claim, and the first DCA said, no, you don't have an inverse condemnation claim, Mr. Burnett, because you didn't own the property when the initial tortious action began by the FDOT. That Burnett controls that. The Palazzolo versus Rhode Island case has been raised in the briefs, in that somehow that case, which was a regulatory case, based on the time needed to ripen a claim, that Mr. Palazzolo, even though he bought the property later than the regulations, the land use regulations were enacted, he had an inverse condemnation claim. That case is limited to its facts, limited to regulatory cases, because it takes a long time to ripen a claim for a regulatory taking. Multiple cases that I've cited in the brief after Palazzolo cite that case for the Mariana versus Maughan proposition that the only folks with inverse condemnation remedies are those that own the property at the time of the taking, in a case like the FARBER case. And lastly, I want to build on something Judge Evander made an argument that or had some questions that dovetail with the argument that I'm going to close with. Under Mr. Farber's theory that the continuing tort concept gives him an inverse condemnation remedy, that logic would allow him to collect damages for loss of access he never suffered, because he never had old A1A access. And then the day after he collected his inverse condemnation damages for that supposed loss of access, he could sell the property to another buyer for fair market value with no A1A access, and then the subsequent buyer could receive inverse condemnations for losses that he or she didn't suffer either. And that process would continue indefinitely, and the law is a lot of things, but it is certainly not geared to reach absurd results like that. So for these reasons, Your Honors, I strongly urge you to affirm Judge Christensen's inverse condemnation summary judgment in favor of the county. And I'll answer any questions at this point if you have any.
All right, counsel, thank you so much.
Thank you. Thank you.
I managed to mess up the clock, but you've got about 4.5 minutes.
That sounds about right. Just a quick point to close on the issue of one property owner being able to move for inverse condemnation damages, and then the next, and then the next, and then the next. If we're successful, there's going to be a judicial pronouncement of a de facto abandonment of the road. At that point, the county no longer has a duty to maintain this public road. It will no longer be a public road. The county's de facto abandonment results in a taking, which means it's no longer a public road. And at that point, it will no longer have a duty.
Yeah,
So-
but the client who came into possession of the property in 2008 or 2009 or 2010 would be able to bring an inverse condemnation.
Right,
Claim
again,
under
assuming
your
we don't have an issue with statute of limitations, right. But what would the damages be? If, I mean, for example, again, I hate to keep pulling this out of the hypothetical, because the market value at the time Mr. Farber purchased the property was $650,000. You would have to think that that includes, within that bundle of rights, the county's duty to repair and maintain that road and provide reasonable access. Because,
I understand your argument on amount of damages, but I think one of the reasons for the general rule, and I know there's exceptions, but for the general rule that that the person who's entitled to make an inverse condemnation claim is the person who's the property owner at the time of the taking, is to prevent that possibility of multiple claims. So it's not, it doesn't just go to the issue of damages, it also goes
think
to the
it's-
issue of determining whether there should be an inverse condemnation claim or not.
right, but this, in most cases, when there's a taking, there's a physical appropriation and it's done. The market value of the property for the subsequent owner will reflect that. It's over. In this case, what the county continually fails to recognize is that it has a continuing duty to repair and maintain this road and provide meaningful access. Mr. Farber was a party in the prior appeal. If this was their argument, you wouldn't have been able to, and if this argument were to prevail, you wouldn't have been able to write that opinion. Because this court's express holding includes Mr. Farber's claim here. And the county just fails to recognize and considers its duty to maintain the road and provide meaningful access as a salutary duty. I mean, you just heard Mr. Gallagher come up here and say there's nothing that anybody can do. You can't enjoin them, no inverse condemnation, so we have a duty, but nobody can do anything about it. That's not the law. That's not what this court held in its prior decision. And with that, we would ask that you reverse the summary judgment against Mr. Farber and now allow for further proceedings. Thank you.
Counsel. All right, that will conclude our docket for the day, and we'll be in recess. Thank you all so much.